Good morning, everyone. Just before I start with the judgment, a few matters of housekeeping. I asked my registrar early this morning to transmit an email to the practitioners. I indicated last week that I will entertain applications for leave to appeal today. On reflection, I've decided against it. I solicited the views of the practitioners, but I got no feedback as I'm sitting here, but that's fine. And the reason for that is, firstly, I expect once I've dealt with a sentence, there'll be a lot of tension, and I want the public then to leave the room, but if we go into leave to appeal, it's going to be difficult. Furthermore, when I thought about the sentence last night and the type of offences that the accused were convicted of, it might be that the defence will need time to reflect on the application and the state to respond thereto so that I can properly consider the application. So the process will be that the defence, if they so wish, can file their applications within the times prescribed in the rules, whereafter the state can respond and we can then set a time and a place for the leave to appeal. Normally, the presence of the accused is not necessary for the application to be heard, and we can schedule that at our convenience in Cape Town, and I can hear the arguments. So I'll complete the sentence portion and then I will adjourn. Good. I do not have a written judgment on sentence. I have a few notes. So I cannot anticipate how long it will be, but I do not intend taking a break. As an introduction, I thought it would be appropriate to repeat the expression of gratitude that I did when I delivered the judgment in the main case. So for purposes of the record, it should be incorporated herein. But having said that, it also dawned on me the effect this matter had on this community. And the need may be that for those decision makers that can have an impact on the community's access to justice, to look at the way forward. As I'm aware, that members of this community has to travel to get to a courtroom in Vredenburg. And I'm looking up there and I recognize the Minister of Safety in the province. There's a real need, I believe, in the context that there's a sad run-up to the events in this matter. Joshlin grew up in a society as was described by Mr. Peterson, the social worker that provided the pre-sentence reports to the court. That was riddled with social problems, and it was evident in this case. Criminality in the sense of drug distribution and the effects that has on the community. The evidence indicated that Ms. Smith in particular was in the need of social services throughout for a prolonged period. And I wonder when her grandmother complained in 2016 to the Department of Social Development in the need for a protection order, what access did she have? When Ms. Smith in particular sought the support of services that is rendered both through the Department of Social Development as well as in the Magistrates' Court, we failed. I started the judgment on the merits by referring to the place of a child in a village and in a community. And when I impose a sentence on the accused today, I have to act in the interest of the community and in protection of the rights of individuals in that community, and specifically with reference to the charges in this case, the rights of children. It's important when one look at the charges underlying the sentence that I have to impose, that act is aimed at protecting the vulnerable within society. And it aims to restore and enforce the human dignity of individuals. So I hope that when we deal with matters like these, that we take it serious. Having said that, I am aware and conscious of the fact that this is the most difficult part of a criminal case. Because I'm called upon as a judicial officer, but firstly, as a human being, to pass judgment on the liberty and the deprivation thereof of other human beings. I was referred to a number of authorities during argument in this case, and was exposed to many more in a lengthy stint of judicial service. I do not propose today to refer unnecessarily to legal precedent unless it's absolutely necessary. Because the judgment is not aimed at the textbooks and the academia and our understanding of sentence in a criminal court, but rather it should be focused so that the accused persons knows what were their considerations for their ultimate fate, and that the broader community can understand the meaning of and the purpose of that sentence. I was constantly referred to the appellate division case, as it then was, in the State versus Zinn. We had a long debate yesterday about how the trits in Zinn and the element of mercy interplay in the determination of an appropriate sentence. I was also referred to the judgment of corporate JA, as it then was, in the State versus Rabi in 1975. And what was apparent in the debate yesterday was that it has a long history of how caution was warned of by writers for centuries of how judges should approach a sentence. I deem it necessary to quote from the case of State versus Rabi in the words of Corbett J.A., as he then was, because this should be a guiding factor for myself in considering the facts and circumstances that I shall turn to shortly. He said, and I quote, "A judicial officer should not approach punishment in a spirit of anger, because, being human, that will make it difficult for him to achieve that delicate balance between the crime, the criminal, and the interests of society, which his task and the objects of punishment demand of him. Nor should he strive after severity, nor, on the other hand, surrender to misplaced pity. While not flinching from firmness, where firmness is called for, he should approach his task with a humane and compassionate understanding of human frailties and the pressures of society which contribute to criminality. It is in the context of this attitude of mind that I see mercy as an element in the determination of the appropriate punishment in the light of all the circumstances of the particular case. It is the duty of the court to balance all the circumstances applicable and to blend that with a measure of mercy in arriving at an appropriate sentence in the discretion of the trial court. I will not repeat all the facts and circumstances and factors in this judgment on sentence. That does not mean I have not taken it into account. I will take into account the facts of the case on the merits, as well as all the evidence presented to the court by the witnesses that testified on sentence, as well as the submissions made from the bar, and more particularly insofar as it relates to Mr. Van Ryn, the further affidavits that were handed up yesterday. Now I need to turn to address Mr. Apollos, Mr. Van Ryn, and Ms. Smith so that they understand how I arrive at the sentence that I will ultimately impose. So normally, in a judgment, the judgment is delivered in the third person, whereas I believe it's appropriate when a court imposes sentence that the court address the accused. So I will take into account various factors that I need to balance. In no particular order and no order of importance, they are the circumstances of the person to be sentenced, Mr. Apollos, Mr. Van Ryn, and Ms. Smith, the offense, and I shall deal with that in some detail, the interest of the community, and important, the purpose of the sentence. Now let me start with the last part first. There is an outcry by the community for retribution. Yes, it is part of the purpose of sentence, because those that harm society must pay for their deeds, and we do that through a system of laws and different types of punishment, therefore. But having said that, it must also serve an important purpose of deterring the individuals yourselves of reoffending, but also generally deter others that would dare to undermine the moral values of society. And there are cases where retribution and deterrence come to the fore much stronger than the other purposes of sentence. I have been asked in argument that I must focus on rehabilitation as one of the purposes of sentence. I'm of the view that there are particular types of cases and the circumstances of those cases where rehabilitation and the potential rehabilitation of an offender is placed on the back burner. We were fortunate in this particular case that we had comprehensive reports from Mr. Peterson insofar as it relates to yourself, Mr. Apollos, Mr. Van Rijn, and Ms. Smith. I shall therefore turn to those circumstances as placed before the court. I pause to note the circumstances under which these reports were produced. It is important that a court, in approaching a sentence and obtaining the necessary information and evidence, act proactively. Because ultimately, as I've indicated at the outset, it is the court's duty to ensure that a fair and a just sentence is imposed. It is for that reason that I requested the pre-sentence reports, which was facilitated through the Department of Social Development in the province, for which I am grateful. Under normal circumstances, courts are requested to grant no less than 6 weeks for these type of reports. I gave them a much shorter timeline. And when it seemed that it was not going to be delivered on time, I exerted some pressure and they delivered. I indicated in open court the other day, from Saturday past, it was all hands on deck. And despite the unfounded criticism that was raised against Mr. Peterson in this court by counsel for the defense, I need to say that over many years, this was one of the most comprehensive reports I've seen. And the diligence and the clarity of thought that went into the reports is commendable. I found Mr. Peterson to be a reliable servant of the people in the manner in which he prepared these reports and presented them to the court. I hope that this type of service is available to all at all times. So, Mr. Apollos, I've noted that you had 2 brushes with the law in the past. However, I'm not going to place any emphasis on those for purposes of sentence in this matter. Thank you. I commented in argument to Mr. Harmse yesterday that I gather from the report that you come from a good home. You had opportunities to progress in life, but you chose a different path. By becoming involved in substance abuse. That changed the trajectory that you could have been on. You're the father of an 11-year-old daughter, and you acted as a father figure to Joshlin and to the other two children of Miss Smith. I shall return later on in this judgment to that fatherly role insofar as it relates to Joshlin. It doesn't seem as if you were gainfully employed for any substantial period and were to a great extent reliant on Miss Smith for your subsistence. What is worrying in your personal circumstances is the attitude you displayed as described by Mr. Peterson. Doesn't seem that you have shown any remorse nor concern about the whereabouts of Joshlin. Instead, you persisted in twisting the truth even on the eve of this sentencing. In your personal circumstances, I do not find any mitigating factors. Mr. van Rijn was described by Mr. Peterson as a menace to society. Had a difficult upbringing where your late father, spent long periods away from home because of work commitments. It was a home that was affected by excessive alcohol use. Although your mother was a strong person that cared. Similarly to Mr. Apollos, it seems that you had the opportunity from the home to live a decent life. But unlike Mr. Apollos and Miss Smith, over and above the drug use and abuse thereof, you chose a life of crime. I do not agree with the submissions that you have rehabilitated. You had multiple brushes with the law for robbery, which was violent offenses. Robbery in itself is an offense of violence. Then you also committed housebreaking. I will not pay much attention to the drug charge. But you were given the opportunity to have correctional supervision and the opportunity to rehabilitate within society, which opportunity you squandered by even not complying with your conditions and had to serve an extra 407 days on a parole violation. I expected a person that have gone through circumstances like yourself, whose father was murdered when you were at a young age, to realize the consequences not only on yourself, but on broader society when families are affected and afflicted by these type of circumstances. Your attitude in this court showed of one that doesn't care. But not only in the court. When Mr. Peterson inquired about your attitude towards the disappearance of Joshlin, you made it very clear by saying you simply don't care. You yourself a father of a young daughter, currently 4 years old. You have shown absolutely no remorse and no concern expressed in your own words and in your personal circumstances. I can find no mitigating circumstances. Ms. Smith, according to the undisputed evidence of Mr. Peterson, from information gathered through the collateral sources, family members that he interviewed, as well as the victim impact statement presented yesterday by your mother, is portrayed as a person that's manipulative and manipulate the facts as it suits you. Went as far as to blame your parents for your conduct in this matter. The evidence presented as to the disappearance of your own daughter was clear. Besides, on one occasion earlier and yesterday, I saw no indication of remorse. But it didn't start there, because we know from the 19th of February 2024, the lack of concern. Yes, I have to take into account that you have 2 other minor children. But fortunately, they are being cared for currently. So the caution that I have to take when imposing a term of imprisonment on a mother and a caregiver, as was expressed by the case of M in the Constitutional Court, bears less weight. Mr. Peterson have, however, also indicated that steps should be, and we heard in the main trial that steps have been taken to ensure for the care of the 2 minor children. I gather from the evidence of Mr. Peterson and the victim impact statement from your mother that you were given all the opportunities. Yes, you were born under difficult circumstances, but you were given the opportunity through your grandparents that cared for you to have a stable life. You, unlike Mr. Apollos and Mr. Van Rijn, that did not fare that well at school, you matriculated. In the victim impact statement from your mother, it was clear that they wanted to assist you even after the onset of the drug use and abuse. You, in a threatening way, pushed that helping hand away. Up till now, I've not seen remorse. So in the personal circumstances alone, I do not find any mitigating circumstances. Now the prosecutor will argue, and have argued, that having found that, the law is clear. If there's a prescribed sentence and there's no substantial circumstances, as I've indicated, that is compelling, that must be the end of the inquiry on the face of it. It's not that simple, because sentence still remains the discretion of the court, and the approach must be that you cannot only focus on the one element. Everything has to be determined holistically, and a balance must be struck. I'm going to start with reference to the prescribed sentences. By indicating that the inquiry must be that the prescribed sentence must be fair and just. If not, the court would be moved to impose a lesser sentence. So I do not deem the prescribed minimum sentence as the only guiding factor in determining the sentence. Let me turn to the next issue, which is the offense. I don't need to stress the seriousness thereof. On count 2, you were convicted of kidnapping. Kidnapping of a 6-year-old child, having the effect of depriving her of a freedom of movement and to liberty. Yes, often one would look at whether there was violence involved or the circumstances that would have harsh effects on the victim. It was argued on behalf of the defense that there's no evidence before the court that Joshlin suffered any harm. There's no merit in such an argument. It must follow by depriving somebody of their liberty and their freedom of movement. It cannot go without at least emotional harm. This brings me to count number 1. The purpose of the act is particularly aimed at the exploitation of a human being for all sorts of purposes. In the particular case, Mr. Apollos and Ms. Smith were in a parental relationship with Joshlin. I want to remind you of the facts of this offense. Ms. Smith indicated in August 2023 to Mr. Kutsia that she was unhappy in her home. She wanted to get rid of her child so that you and Mr. Apollos could have a better life. How callous is that? I'm reminding you, I'm speaking of the offense. Then there was the interventions which I cannot ignore during the period, Ms. Smith, that you had to go to the rehabilitation center on 2 occasions. First one was when Joshlin was a baby. Andrew's family took care of her. And I'm fast forwarding to the victim impact statements that we had. And I will return to it again and remind you constantly of it. On the day before, the 19th, being the 18th of February, the discussions took place after an incident that had upset you. And that was the alleged charge of the chicken theft that somebody dared, in your view, to lay against Mr. Apollos. Because you expressed the views that you're going to expose the complainant for daring to name him as a suspect. That led to a heated argument between yourself and Mr. Apollos. Eventually, Joshlin being dragged towards the house. An independent witness came to tell us that. That conduct seems not to have been an isolated incident, because I remind you of the evidence of Mr. Peterson, of what the collateral sources had told him. and this went unchallenged of your actions towards her. That's when the discussion took place. According to Mr. Apollos, the motivating factor was you again putting the blame on others for treating your child as a commodity and selling her off. Miss Lombard and Mr. Van Ryn went along. Both of them parents of small children. Mr. Van Ryn, your daughter would have been 3 years old or younger if she's 4 now. Then the plan are being put in place. I pause to remind you, I'm talking about the offense. Next day, for 20,000 rand, Joshlin is sold. Nobody knows where she is. The victim in this type of offense and the treatment of the victim is important. Dr. van der Walt reminded us of some of the factors that the Act says I must take into account. And I said at the outset, I'm not necessarily going to tabulate them, because I want you to understand the seriousness of the offense. Mr. Apollos tells us that on the morning of the 19th, he fed Joshlin. He cared for her, he says, looks her in the eye and sells her. And Mr. Apollos, then you sit there and you say nothing. This is the offense. Betraying the trust that she must have placed in you, Mr. Apollos, as a parent, although not her biological father, and you, Miss Smith, as the one that gave birth to her, and you, Mr. Van Ryn, being that good friend and the father of a small child. Turning back to the offense itself and the effect it has on the community, we've heard, and I've heard, the victim impact statement of Ms. Olivier. Joshlin was a child in the community. We heard how she would go to some of the houses on the evidence presented here, including Ms. Olivier, and how she would sit at that table. Ms. Lombard, and I am going to deal with her situation in a different hearing, also looked Joshlin in the eye, gave her something to eat, and did nothing to protect her. The society and the community of Saldanha was torn apart. We heard about the extensive searches that took place and a victim because the broader community are victims, saying to me through the statement yesterday, I still cannot wear the clothes I wore when we searched. We're 15 months in. We heard in the evidence on the merits trial that people are still searching. We heard about people from all over that came. And the resources employed. But the community was fractured by the conduct of the three of you. Ms. Mart speaks on behalf of her children, she says. And sometimes she refers to them as her learners. In her evidence in the merits trial, she referred to the person who called her as one of my mothers, referring to a mother of a child in her class. We saw the tree. We saw the fingerprints of those young kids who would now be in grade 2. And the missing one. We heard the evidence of how a community has become more concerned that the children or their children doesn't go missing. Ms. Mart tells us that it became more of the norm that parents would drop and fetch their children because they feel unsafe. That's the effect your crime has had on the community. Ms. Daniels, I apologize that I have to single you out, but I've heard you. When your son, Ms. Smith, goes to school or rugby practice, your mother doesn't know if he's just a wee bit late, how to deal with it. And I am sure it's not only the Saldanha community or the extended family that's affected by this. Community has been affected to the extent that we fortunately saw people uniting and rallying in the defense of children. And if there's one positive that have come out of this case, is what I saw by having the fortunate opportunity to serve, in this case, in this place, of how disciplined the community can be and how united they can be in the defense of the dignity of the community. Now, because the community has an interest in the offense, they have certain demands, and they have certain outcries. I'm sure there are many that would ask for a sentence that would be inhumane. That's why we did away with it. Because they don't see even a life imprisonment as enough punishment for the harm done to the community. But then I remind myself on what I read out to you earlier in this judgment. I spoke of the two aspects of the purpose of the sentence. And I spoke of how one should balance these factors. I tried to explain to you how your personal circumstances and the offense and the interest of society interacts in the determination of the sentence, and how I caution myself of trying to be compassionate, to be humane, to show mercy, not to have anger, not to have the anger of the community affect me to the extent that I act not in the interest of the community, but rather adhere to the wishes of the community. I try to stay away from that. I've referred to the minimum sentences and the prescribed sentences. And yes, if I heed the request of the prosecution, I should impose life imprisonment. But let me think of the options in explaining to you. It's clear that a sentence of imprisonment is the only appropriate sentence. The question is just how long. You are all three relatively young. And yes, one of the purposes of a sentence is to rehabilitate the offender. And I'm well aware that there's always that potential. How do you balance the interest of society and your own prospects of rehabilitation when somebody commits such a heinous crime? I'm of the view that even if I was not bound by a prescribed sentence, I would still have considered the harshest sentence I could impose. Because to my mind, balancing all these factors and circumstances that I've indicated to you, it would indicate your moral blameworthiness. And saying that, I do not forget that at the time of the commission of the offences, you were using and have been using substances that could have had an effect. But it's no excuse. Because if it was a factor that affected and led you to the commission of the offences, you had the opportunity to tell me. But I didn't think straight at the time because I was under the influence. You simply didn't do that. In fact, it seemed through the course of this trial that you, Mr. Van Ryn, and Ms. Smith, you found it amusing. At one stage I indicated to you that when certain witnesses were testifying, I don't see the captain here today, you were celebrating. Didn't take it serious. There's nothing that I can find that is redeeming and deserving of a lesser sentence than the harshest I can impose. I'm well aware that the second charge was part of the whole planning. And I need to temper the effect of that sentence. Before I announce the sentences in this matter, the prosecutor requested me that I should order that your names be entered into the National Child Protection Register. In the circumstances of this case, it is an order I'm going to make. Lastly, I indicated in the merits trial my disappointment as to the proper compliance with the Poker Tip Act by the administrative systems to be put in place. I would urge the government role players to ensure that it is done rather sooner than later, because it is aimed at protecting the vulnerable and achieving the objectives of the Act. I cannot make an order because I don't have sufficient detail. Mr. Van Ryn has already been declared unfit to possess a firearm. In considering that result for Mr. Smith and Ms. Apollos, I need not make an order because of the sentence I will impose. There's no prescribed sentence for the kidnapping charge because of the severity of the facts of the kidnapping as it relates to a minor child. I'm of the view that even for that charge, a long-term imprisonment should be imposed. So for the reasons that I've expressed, and I hope you understood, I'm going to impose the sentences now. May you stand. Mr. Polis and Mr. Van Rijn and Ms. Smith, I'm going to announce the sentences at the same time because your sentences are the same. I'm not going to draw any distinction, even though Mr. Van Rijn has previous convictions and you, Mr. Polis and Ms. Smith, does not have. On the human trafficking charge, you are sentenced to life imprisonment. On the kidnapping charge, you are sentenced to 10 years imprisonment. Because I've imposed life imprisonment, there is no need for me to rule on the concurrency of the sentences, because by operation of law, it will be served concurrently. Mr. Polis, do you understand that? Mr. Van Rijn, do you understand? Ms. Smith, do you understand? Thank you. You may be seated. I'm also ordinary for the entry of your names into the National Child Protection Register. The court adjourned.